Welcome to the next segment of War Story Wednesdays. Today I want to talk about a case that is a plaintiff lawyer's dream and a real estate broker's nightmare. Imagine you are responsible for the sale of a 5-acre piece of property just outside the Central Valley. Rolling hills, meandering streams, beautiful oak trees, a house that you can sit on the porch on your rocker and just enjoy a summer sunset. And you know that there are easements over this property, you know, power lines and waterways and that kind of stuff. And you're just not paying enough attention to the details. So your client comes to you and says, I'd like to buy this beautiful piece of property. And you think this is terrific. And you hurry up and get the deal done and you close escrow. The problem is you don't even get a preliminary report before the close of escrow. And you didn't check permit histories, and you didn't verify the acreage. And it turns out, oops, it's not the same amount of acreage. And that house was built over the setback lines. Oh, and there's a water easement because it's in a flood zone. And in fact, the flood zone allows the flood waters to permeate the land, including parts of where the house is. And you can't rebuild to move the house out of the floodplain. The buyer is understandably unhappy with the real estate broker at this point, but doesn't find out about all of this stuff until 2 years after the close of escrow. And the real estate broker says that there's this code, section 2079, that says that the real estate broker for the seller, the listing agent, has got a 2-year statute of limitations. And that should apply to all real estate brokers involved in the deal, because this real estate broker represented both the seller and the buyer. And the court said, yeah, not so much. The court determined that the real estate broker representing a buyer had a duty to learn of the material facts affecting the property and to investigate, that the broker was expected to do the research necessary to be able to give their client competent advice with respect to any material issue relating to the property. Like, say, for instance, it's in a flood zone. The statute, with regard to the duties owed by a listing broker, don't insulate or isolate or protect the selling broker, the broker representing the buyer, from any similar breach of fiduciary duty. This case has been used over and over and over to nail a buyer's representative for failing to do even basic research into issues that will affect the desirability or marketability of a piece of real estate. As a buyer's representative, it is your job to make sure that the buyer has all the information that buyer needs to make an informed decision. There is no easy way out, and there is no simple, diligent visual inspection of accessible areas. Your duties as a representative of a buyer far exceed the limited duty that a listing agent has for its client.